Convicted murderer, so-called Doomsday Mom Lori Vallow Daybell returns to the courtroom, this time in handcuffs and her orange jumpsuit, ready to represent herself again as her own attorney, accused of conspiring to kill her ex-nephew-in-law, Brandon Boudreaux, the lone survivor in a deadly saga that began in 2019. The pretrial hearing getting intense as Daybell calls out the judge 2 weeks from the start of her final Arizona trial. I'm Justin Lum, and we are on the record. Lori Vallow Daybell accused of conspiring to kill her former nephew-in-law, Brandon Boudreaux. This is a case that we have been watching for a long time, and her final Arizona trial will get underway in about 2 weeks. Fox 10 investigator Justin Lum here, joined by special projects executive producer George Obi, and quite a hearing we had today. The pretrial conference, really the last time that all the housekeeping gets in order as far as pending motions and arguments before this trial begins, and Lori Vallow Daybell representing herself as her own attorney. A lot of housekeeping done, but we did not expect what happened later in the hearing that, of course, we're going to get to in a little bit.
Yeah, we'll get to in a little bit. Again, the final chapter of this entire saga. Here we are some 6 years later. You were in court this morning. You had a better view of it, a front row seat of what went down. We've been through a few of these pretrial hearings, pretty cut and dry for most of them, but then
this one was weird.
Yeah,
it was weird and bizarre, and you can see that Lori Vallow Daybell, she has nothing to lose. We've talked about this many times. She has nothing to lose. Already serving 3 consecutive life sentences for murder convictions in Idaho for her killing her 2 kids and conspiring in Tammy Daybell's death. Now newly convicted of conspiring in the murder of her 4th husband, Charles Vallow. And now she has one more trial to represent herself. And a lot of people have said in the comments, this is her opportunity to get out of jail. She's in solitary confinement for 23 hours a day. And this is her time to be around people, be around other lawyers, and to really be in control. And that's what we've learned about her, is that she likes to be in control, but it didn't work out in her favor today with Judge Beresky.
No, and this gives us a window, as we've mentioned before, a window into who Lori is as a person and how she handles all of this. We have seen a lot of video over the years, a lot of interviews. We've gotten a sense to kind of know who Lori is from the outside looking in, but here you have someone who's representing themselves, who is putting themselves out there. Again, nothing to lose from her perspective, but you're getting a clear picture of who Lori is as a person, not just as her own attorney. And I think we saw a little bit of that during this fiery exchange that we'll play here in a minute between her and Judge Beresky. I think this is, if you really want to know who Lori is, this is a little taste of that.
And let's go over some of these motions, though, because here's what we know. She's going to get more time during the lunch recess, which is about an hour and a half during trial. She requested to get time with her advisory counsel, and we may have assumed that she already had that time and was able to basically brief and game plan after the morning session during trial. But in this case, you need a MCSO detention officer to be there. There are schedules, there are lunch breaks and things of that. So MCSO basically said, we have no objection to that. There's a place in the South Court Tower where she can meet with her advisory counsel, including her paralegal and her investigator, to talk about what they need to talk about each day. So that gives her a little bit more of an edge or an advantage, something that she may have not had in the last trial. She also motioned for no restraints during trial. We know she had to wear the rack belt, and so she went back and forth with Judge Beresky a little bit about that, and he said, well, the MCSO recommendation is that you wear the rack belt, and you won't have to wear this leg brace because you have to move around, you have to talk and stand at the podium, but the rack belt is needed. Also, expert witnesses. We've heard the name Lonnie Dworkin, the digital forensics expert, who still has yet to disclose a report that would be needed for him to be an expert witness, so that report could be reviewed by the prosecution. She has another ballistics expert that she says she would call on to rebut whatever the state argues and presents about the shooting at Brandon Boudreaux outside Gilbert. But again, no reports have been disclosed, and so she's way past the due date. Judge Beresky says. So in a sense, you may not even have these expert witnesses. But what was interesting is that when she said the name Melanie Gibb and the name Zulema Pastenis, her former best friends who were part of this inner circle, led by her and Chad Daybell and key witnesses in the Idaho trials to talk about the religious beliefs she held, identifying family members as dark spirits, and having knowledge on Brandon Boudreaux. I don't know how this would help her, but she wants to call on her old friends.
Yeah, we saw in the first trial how she went and you know, brought her other witnesses up, or how she grilled even during cross. We saw how she handled that. I am curious to see how she's going to handle, crossing people that she was so close with, and how much Trina K objects to that, and how frustrated Lori's going to get when she starts running into questions that she can't get answered or that she's not allowed to ask in court.
And this may not even happen, but she made it clear those are people that she wants besides Detective Nathan Moffitt, who was going to testify in the first Arizona trial regarding Charles Vallow, but the state was fine. They went with 19 witnesses instead of 21, I believe. So Moffitt never took the stand. She wants to talk to Moffitt. I don't know. This is a different investigation, though. That was the Chandler shooting. This is the Gilbert shooting involving Brandon Boudreaux. She told Judge Beresky today that Gibb and Pastenis have relevant information on not just Brandon Boudreaux, but also Alex Cox. And he kept asking her, well, how are they relevant? You can tell me they're relevant, and it doesn't mean that they are relevant at all. And right now, you guys are looking at video. This is Melanie Pulowski, formerly known as Melanie Boudreaux. This is Brandon Boudreaux's ex-wife. This is Lori Vallow Daybell's niece. We have not heard her name come up.
No.
But it is important that you see her and know that he had concerns about her religious beliefs and how she was following the path of Lori Vallow Daybell. He said in court, it's on the record. And then there's video of her walking into a family court hearing where I was basically chasing her down and asking her questions about where were JJ Vallow and Tylee Ryan at the time. We had no answers on where they were. She has not been called to testify. Is not listed.
No, and she has not been called. And this is one of the people I think that those who follow the case have wondered, why is she not being questioned? Why was she not involved in any of these trials? You could argue that she has some information related to at least this case. Yeah. You're going to hear her name a lot in this case. You're going to see a lot of evidence, I'm sure, between Lori and her, that the state wants to include. I'm curious why she hasn't been called to testify either.
And Gilbert police say that she is the only one that had Brandon's new address at the time. He had just moved into that home, and so that she would be the only one to provide that information to Alex Cox and Lori Vallow Daybell. So now to be clear, in the first trial, she got herself dismissed because she had seen Brandon Boudreaux's testimony. She said that you cannot do that.
Right.
The second trial, minor involvement, a small testimony, really was her husband Ian Pulowski's testimony that was more intriguing and more interesting. But we don't expect to see her here, and it's unknown if the judge will find that Gibb and Pastenis are relevant, because Lori wasn't giving away her cards on what they actually know, even though we know how much they know about all this.
And they've already, we've seen them in previous trials. We've seen both of them testify, phone calls that were played, things like that, the interrogation video, which we just showed a minute ago from both of them. And we had talked about it too. Where does Trina go with both of them? Because it feels like those two will be key to the case as well, at least from the state's perspective. Will they help Lori, or will it hurt Lori? Yeah,
they testified against her in the Idaho trial. Why would they want to help her? Obviously, if you were subpoenaed and had to testify, you'd answer the questions truthfully. But Trina K would definitely have some good cross-examination questions about what Lori believed in and how she allegedly identified Brandon Boudreaux as a dark spirit. I think it was Melanie Gibb who had said that the crew, the group, had likened Hitler as bad as Hitler at that
Wow.
level.
Yeah.
And so it's strange and bizarre to say and to hear. But yeah, I just don't know how they would help. Now, another thing, Lori had an issue with her name being on the questionnaire when it got into it with the judge about why that shouldn't be on the questionnaire. And he said, I do this for every trial. We need to weed out who knows your name and your case.
Yeah. Yeah. And this was a big topic in the last case. We are going to look at whether or not that is going to make it more difficult to seat a jury. Again, 12 jurors, 4 alternates, same as last trial. You could argue that everything that we've seen just within the last 2 months here in Arizona, that you probably are going to have more people who have heard the name, that you have more people who have some familiarity with the case. But we saw that the previous jurors. We saw a couple of them say, yeah, look, it's come up on my feed, or somehow it was suggested to me, a video about Lori. And yet they were allowed to stay on the jury pool, or at least as an alternate. Who knows? I mean, who knows if that muddies the water a little bit? But we are 4.5 million people in this county. I would imagine that they're going to be able to find 12 and 4 alternates, no problem.
All right, so this was the courtroom curveball that I didn't expect. Let's take a listen to the exchange Lori Daybell spat with Judge Beresky.
Your Honor,
Yes.
I would have to ask that you would recuse yourself from the obvious personal bias that you have against me and send us to master calendar for this scheduling of a trial.
And what personal bias is that?
A lot, obviously, the personal bias that you're showing right now and that you've shown on the FTR several times during the trial.
Okay, well, I don't have any personal bias, all right? I've over-accommodated you on when you have to disclose things. In fact, your expert should be summarily precluded today, and I haven't done that, all right? So
You denied every single one of my motions since for a year and a half that I've been here. Every single one of my motions has been denied. And have any of those motions not have merit? You've denied every single motion.
I think I was here this morning about 15 minutes ago when I granted your motion to meet with your attorneys over the lunch hour. I have granted other motions of yours, okay?
That's the first motion that you've ever granted
Well,
in my behalf.
file motions that have a legal basis and I might grant them.
So you're saying none of my motions have had merit?
Not many, no.
And none of the motions that my first team, you denied every one of my first team's motions, you denied every one of my second team's motions, and now you've denied every one of my motions until today.
I haven't denied every one of your motions.
Every single one of their motions was denied, every single one of the second team's motions were denied, and all mine. So you didn't come into this with any bias against me in the first place?
Again, file a motion that has legal merit, okay?
And none of my attorneys ever filed a motion with any legal merit?
They filed a motion on your behalf, the first team, to preclude media coverage, and I issued my ruling according to the law, all right? They filed a motion to have you dressed out, not in jail clothes during hearings like this, okay? That was not based in law. I denied that motion. So I've ruled on the motions as required by law.
Without any kind of a conclusion of law in them, just denied, 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 denied. Does that not show a bias and a prejudice against one single person?
All right, are you done?
Are you not going to recuse yourself?
No, I'm denying your motion.
That's the quote of the day. Are you done? Judge Beresky asked her multiple times. I think this was the most visibly frustrated we had seen him with her, even though he is staying pretty calm. But she does not let up. And she's not really being truthful. She's not, because there are motions that have been granted, including from her original public defender team who wanted to go into the Rule 11 competency evaluation. He granted that. And then when she gets a new public defenders and they want her out of it, and it's proven that she is competent and she wants to represent herself, that was granted as well. And the civilian clothes that he just mentioned about wearing that in trial.
Yeah, again, she's not a lawyer. We do wonder what her legal team is, the advice that they're giving her. And did they say, look, if you feel strongly that you want the judge to recuse himself, now is your opportunity to make that argument. I'm not sure she made an argument Like we kept waiting. Like he even said, "Well, based on what? Like what is it that you feel like I'm biased towards?" And she never could get into specifics. Um, so where does I just don't understand what her legal advisor is saying to her. Look, you can make the argument. Here are the bullet points that you should be arguing. Specifically, this. She doesn't have any of that. But again, she has nothing to lose.
Yeah.
Is this more about show? Is it more of just getting it on the record?
Yeah.
Or is it more of her going, no matter what happens in all of this, she knows that she's going right back to Idaho when this is over?
There's been a handful of motions to dismiss the case that have been denied because, as Judge Beresky says, you have no reasoning or actual merit to get these cases dismissed. And if you watch the full hearing, she also brings up the alleged juror misconduct, which has been talked about
Yep.
after the trial, where the juror said that, he was thinking about how she has to serve 3 life sentences consecutively. But there are also other interviews where he cleared up that he didn't know anything until Googling the case after giving out the verdict.
Exactly, and that was the state's response. Made it clear that he had said moments earlier that as soon as the verdict was read and the jury was out of the courtroom, everybody, including him, started Googling her name, and that's when it came up. And so, this is part of I think any playbook from a defense attorney. But a real defense attorney would have made a more compelling argument this morning in the this idea that Judge Beresky is being that he has some personal vendetta against Lori. I guess any good defense attorney would have put up a much better argument.
Let's talk about when trial will start. It's slated to begin June 2nd as far as opening statements. But really, the juror questionnaires will be sent out next week, expected to be back by the 27th or 28th, and they're going to go over these questionnaires on May 29th.
Yes, and one of the things they had discussed earlier was when they were setting the timetable for this trial, they brought up the fact that, look, we want to make it clear to the jurors that this trial isn't expected to go past the end of June. They want to get it done by June. Judge Beresky's moving on. But they also don't want to give the jurors the impression that they may be in court for July 4th for the holiday. People have plans. They're going to be like, no, I can't be here.
People want to get out of it.
Right.
Yeah.
Right.
Trina K also, she went from saying she needs 5 to 6 weeks in the first trial to saying by June 9th, I could only have like 3 witnesses left and I'll probably be done. So it's changed drastically as far as the time frame that really by the time she's done with the case in chief and whatever Lori has to rebut, and I don't know if she has any witnesses that she will actually be able to call, that they're saying the earliest, June 13th, we could have, be done with this trial.
And even Trina mentioned that those last remaining witnesses need to be called during that week because they're only available then. Had all of these witnesses, her 22 that she has, if they're all available that first week, she thinks she can get through them all in the first 5 days. Yeah,
so we may have some off days on June 5th and June 6th where they could go dark and have short days. We'll see, but we're going plan to do a Monday through Friday instead of Monday through Thursday. But we'll see what happens. We'll see what witnesses Lori has. I mean, we know she has disclosed who she wants to call, but are they relevant in the court's eyes? Will they be precluded? And will she testify? Always the big question. We have to ask it.
I think less likely she would testify in this case. It doesn't seem to hold as much weight, but she knows this is it, right? This is as we're calling it, the final chapter.
Yeah.
Maybe this is her way of saying, all right, this is it. This is it for me. I'm going to go back to Idaho, but yeah, I'll take the stand. I don't. Maybe she thinks that, well, it won't help her hurt her. Why not? But again, she's got to have questions prepared for her legal counsel to ask her. This is not her opportunity to give a sermon, if you will. And then, of course, you have to leave it open for Trina to cross. And she may not want to put herself in that position.
And we will find out at the end of May, too, as far as the Rule 609, where the state wants to bring up her latest conviction, conspiring in the murder of Charles Vallow. But she obviously hasn't been sentenced for that and won't be until this next trial is over. So that's sort of up in the air as well. But the judge wanted to table that until we get into the jury selection process. So a lot that's still unknown as far as witnesses and what will happen with Lori's criminal history and how that will be if mentioned at all somehow. But it's going to be interesting. This is the final chapter, and we will be streaming everything here on our YouTube channel, just like we did for the first Arizona trial. On the Record is going to be daily as well. So like, subscribe, hit the bell for notifications. For George Obi, I'm Justin Lum, and we will see you guys next time on The Record.